The hypocrisy here is abounding. That your office does not have police powers.
Objection deemed admitted.
Admit your ass, Mr. Gilson.
Made accusations you were involved in an affair with the Northampton County Orthonotary.
In emails, on the record, under oath.
He accused you of being dirty.
So his reputation over the last 35 years speaks for itself.
When judges rule against attorneys, those attorneys may object. They may even strenuously object, but they almost always take it and move on. Not this sheister. Meet Easton, Pennsylvania attorney Ron Creazzo. He was recently convicted and sentenced to 1.5 to 4 years in prison on 6 counts, 3 of which were felonies. He also had 6 contempt charges, and he was twice arrested for violating a protection order, which I assume exists to protect this judge from this sheister's hard-on. Now, Creazzo the Clown Show faces disbarment, and it's never a good sign when a senior judge shows up to testify against you. Let's roll roads.
Thank you. My name is Jennifer Tobias, and I'm representing Office of Disciplinary Counsel.
Good morning. Mark Gilson, appearing on behalf of the Office of Disciplinary Counsel.
Right, Mr. Criazzo.
Ron Creazzo, apparently the respondent here.
Thank you. And I should have said at the beginning, this matter is captioned Office of Disciplinary Counsel versus Ron Creazzo. The respondent is hereby notified that after this hearing committee makes its finding on the issue of alleged misconduct, the participants are then entitled to offer any evidence which is relevant and material on the issue of the type of discipline to be imposed. In the event the board finds public discipline in the form of disbarment, suspension, probation, or public censure to be appropriate, the board's decision relevant to the alleged misconduct and/or the type of discipline to be imposed is not considered a final order, but only a recommendation which is submitted to the Chief Justice of the Supreme Court of Pennsylvania for the court's deliberation. The Supreme Court of Pennsylvania, in turn, will consider the matter de novo and will issue a final order either accepting the recommendations of the board, dismissing the petition for discipline, or increasing or decreasing the type of discipline recommended by the board. In the event the disciplinary board concludes that a matter should be resolved by public reprimand or private discipline, the participants have limited rights to request review of the board's findings by the Supreme Court of Pennsylvania pursuant to the Pennsylvania Rules of Disciplinary Enforcement. Again, once the matter reaches the Supreme Court, the court has the power to increase or decrease the discipline recommended by the board. So at this point, I think we're prepared to proceed. Would the Office of Disciplinary Counsel like to make an opening statement?
So
Yes.
I'm not prepared. Actually, Mr. Chair, I'm not prepared to proceed. I'd like to request a continuance today. I'm at a severe disadvantage. I don't have the petition. I don't have any of the documents. I've been incarcerated since October 27th. So I haven't had an opportunity to participate and respond and do what I need to do here. In addition to that, there were limited resources in the facility where I was. So there was no pens available, paper, et cetera. So I couldn't participate in the process due to lack of resources. This is the first request for continuance. I'm here at Camp Hill, right around the corner, I guess, somewhere here in Harrisburg. This is the first request for a continuance. I didn't even know about this particular hearing until Mr. Gilson approached me on or about December 5, which was my sentencing date. And I was incarcerated prior to that. The judge put me in jail on a probation, on the bail violation. So I've been restricted and have had limited resources available to participate and or to represent myself in this matter. I've also had limited telephone contact, which means I was not even able to reach out to try to.
If I may, I do object here. Mr. Criazzo's request for a continuance has been considered and denied by the disciplinary board chair.
Yeah, okay.
Thank you.
I wasn't aware.
Mr. Criazzo, excuse me.
I wasn't aware if you received a written request or not.
All right, Mr. Criazzo, you did make a written request for a continuance, which was addressed. by the chair of the disciplinary board, and that request was denied, I believe, on Friday, this past Friday. So a further request is not appropriate at this time. The request for a continuance was made and denied, so we will proceed today.
ODC, members of the committee, ODC would make the following opening statement. On August 18th of 2025, ODC filed a petition for discipline in this matter. The next day, August 19th of 2025, that petition was personally served on the respondent. The respondent failed to provide an answer within the required time pursuant to Enforcement Rule 208B3 and Board Rule Section 8954D. All factual allegations set forth in the petition for discipline are deemed admitted. Furthermore, pursuant to Enforcement Rule 208B4 and Board Rule Section 8993D, no evidence with respect to any factual allegation in the petition for discipline that has been deemed admitted may be presented at any hearing on this matter. Therefore, pursuant to the disciplinary rules, all factual allegations submitted in the petition are deemed admitted, and no other evidence regarding those factual allegations deemed admitted may be presented. Accordingly, ODC has no witnesses to present in this hearing, and in fact would be precluded from presenting any witnesses to testify as to any factual allegations. Rather, we would move into evidence ODC exhibits 1 through 78 in their entirety. Note for the record that copies of ODC's exhibit were personally served on the respondent on December 12th of 2025, and pursuant to the hearing committee's order, ODC did not receive any objections from the respondent as to their authenticity or admissibility. With the admission into evidence of ODC exhibits 1 through 78, ODC rests its case in the disciplinary part of the proceeding and asks the board, or asks the hearing committee rather, to make a prima facie finding that at least one of the charged rules of professional conduct have been proven. Pursuant to the rules, you do not have to specify which of those charged rules has been violated. Thank you.
Mr. Creazzo, do you have
Yes,
a
Chairman.
brief opening statement?
Yes, Mr. Chairman, very briefly, that here's the hypocrisy of this entire proceeding. You have a rule that says an attorney may not be a witness and an attorney in the same proceeding. Mr. Gilson has participated as a witness and an attorney in this entire proceeding from the beginning to current. He appeared in front of Northampton County Court of Common Pleas, Judge Mahone, on December 5, 2025, and indicated that he was still co-counsel in this matter. He cannot be co-counsel and a witness in the same case. The hypocrisy here is abounding. It's astonishing. In addition to that, there are factual allegations that I can get into, the first of which is that your
Objection.
office is not.
I object to counsel making any argument regarding factual allegations that are deemed admitted.
Oh, Mr. Creazzo, if there's an objection, please stop talking and we'll hear the objection.
My objection is pursuant to the rules, counsel cannot engage in any factual statements or arguments, as to factual allegations that have been deemed admitted. It is not permissible.
Again, Your Honor, I did not have the resources.
Wait, excuse me, Mr. Creazzo, please wait. Objection sustained. Mr. Creazzo, you cannot address facts which have already been admitted.
See, I don't even know what facts have already been admitted. The only thing I can tell you is that your office does not have police powers, and this gentleman and his goon trespassed on my private property.
Objection. These are factual allegations that are deemed admitted.
Sustained.
Admit your ass, Mr. Gilson, and stick him up.
Wait, all right, hold it. All right, that's enough, Mr. Criazzo. You've worn out your welcome on your opening. Your opening statement is complete.
And these two clowns. The hypocrisy is a
All right, Mr. Criazzo, we're not going to listen to this. I'm going to ask that they mute you if you continue talking like that.
Mr. Gilson should be facing a perjury charge.
All right.
for
Objection.
a criminal case.
Sustained. All right, Sarah, could you please mute Mr. Criazzo?
From the city of Philadelphia, DA's office.
Objection.
Sustained again.
Fired from the DA's office, Mr. Gilson.
Mr. Scott,
Yes or
Criazzo.
no?
mute him or no? Okay.
All right, Mr. Criazzo, your comments were wholly inappropriate in the context of this hearing. And you did not listen to me. So we have put you on mute. I will ask you at appropriate times if you have comment.
Uh-oh, there he goes.
That's fine.
Well,
Mm.
okay, I will ask you at appropriate times if you have comment, and if so, you can comment. But if necessary, we will enforce that you not be able to speak if you continue to make inappropriate comments. So with that, I would ask the Office of Disciplinary Counsel to present your case.
Thank you. I move for the admission into evidence of ODC Exhibits 1 through 78.
There was a pre-hearing order about the exchange of exhibits and requiring that a party, that the respondent state any objections to those exhibits within 1 week. It's been represented that no objections were stated, so any objections are waived, and the exhibits 1 through 78 are accepted into evidence.
Thank you, sir. I would then ask that the hearing committee make a finding that ODC has proven a prima facie violation of at least one of the charged rules of professional conduct.
Okay, well, at this point, I would, does the ODC rest from its case in chief at this point?
Yes, I'm sorry. At this point, I think there's a,
Can you,
can we go to the here to
Mr.
Camp Hill?
Scott, could you unmute Mr. Criazzo, please? I believe okay, I'm sorry. Sarah, could you please unmute Mr. Criazzo? Okay,
Yes, I did.
thank you.
All right, Sarah, I see you standing there in uniform. Could you state your name, and is there something you want to tell us?
My name's Officer Michael Kaminsky. Right now, Creazzo is refusing to take part and sit in a room.
All right, thank you.
Could you spell your last name for the record, please?
It's Kaminsky.
Thank you.
Yes, sir.
Mr. Mulhern, is it possible that we can just continue the hearing and then keep the WebEx up for Mr. Criazzo? And then if he chooses to participate, we can continue. And if he chooses not to participate, then that's his choice.
Yes.
Okay. So, sir, if you could just keep the live stream going from SCI Camp Hill, and then if Mr. Criazzo chooses to participate, then that's his choice. And if he chooses not to, that's his choice as well. Thank you.
You're welcome. Thank you.
Thank you. I would,
Mr. Gilson.
I would just ask that the record reflect that it is approximately 9:54 a.m. And at this time, Mr. Criazzo has removed himself voluntarily from the disciplinary proceedings and is refusing to proceed or attend.
All right, thank you. I was starting to ask where ODC rests if Mr. Criazzo had any evidence to present. And that was when he left the video.
Right.
So he is no longer with us as far as we can tell. And with that as his declining, the offer to present any evidence at this phase of the hearing.
And for the record, I don't know if I stated it or not, but ODC does rest its case with the admission into evidence of its exhibits numbers 1 through 78. Thank you.
Okay. The hearing committee has deliberated based upon the evidence that was presented and finds that the Office of Disciplinary Counsel has established a prima facie violation of at least one of the disciplinary rules alleged in the petition for discipline to have been violated. In that case, under the procedural rules, we will move toward the penalty phase of the hearing.
First of all, ODC would move for the admission and evidence of its exhibits relevant to aggravating factors, which were previously marked as ODC Exhibits A through DD.
As with the exhibits for ODC's case in chief, where no objection was provided and where Mr. Criazzo is not objecting at this moment, the exhibits ODC A through DD are admitted.
We have one witness that we would like to present regarding aggravating factors, and that is Northampton County Court of Common Pleas Judge Anthony Beltrami. He will be testifying remotely.
Will the judge be sworn as a witness? Okay. Yes.
Please raise your right hand. Do you solemnly swear that the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You are free to proceed.
Thank you. Good morning, Judge Beltrami.
Good morning.
Are you a duly elected judge of the Court of Common Pleas of Northampton County?
At this time, today is my first day as an actual senior judge. I retired.
Okay,
again
congratulations.
this year. Thank you.
How long did you serve as a Northampton County Court of Common Pleas judge before assuming senior status?
20 years.
Do you know the respondent in this matter, Ronnie Lewis Creazzo?
Yes.
Prior to today, did you have an opportunity to review ODC exhibits 1 through 78, as well as ODC exhibits relevant to aggravating factors A through DD?
Yes.
Specifically, did you review those exhibits in which Mr. Criazzo made false statements regarding your qualifications and integrity as a sitting judge?
Yes.
Did you also review ODC exhibits where Mr. Criazzo accused you of lying and testifying falsely under oath at a prior related disciplinary proceeding?
Yes, I did.
In those exhibits, did you see where Mr. Criazzo repeatedly and persistently made accusations that you were involved in an affair with the Northampton County Prothonotary?
Yes, I saw that, and he began those allegations after I filed a disciplinary complaint against him, and he also accused the same prothonotary of inappropriate behavior with other judges and other attorneys.
Are any of those accusations true, sir?
No.
Did you see in the exhibits that were provided to you, Mr. Criazzo's accusations that you were motivated to file a disciplinary complaint with the Office of Disciplinary Counsel to retaliate and revenge alleged comments that Mr. Criazzo made to the Northampton County Prothonotary?
Yes, and I became aware of his delusion, I believe, in May of 2024 when he sent me a very inappropriate email in which he first started alleging that, and that was probably 6 months after I filed the complaint. Or maybe that was 2025.
Did he make those accusations in emails to yourself?
Yes, he's made them in emails to me.
And in the exhibits that were provided, did you see where he made those accusations in emails that he sent to ODC?
Yes, he's repeatedly been saying this in emails, on the record, under oath, everywhere he can.
Did you see where he made those accusations during his testimony at a prior disciplinary hearing?
Yes, I was there.
Did you see and read where he made those accusations in argument and in statements to that hearing committee?
Yes, I did.
And amongst the exhibits that you were provided, did you also see transcripts from hearings that were unrelated to the disciplinary proceedings where Mr. Criazzo made those accusations on the record in open court before other judges?
Yes, I did see that. And those other judges actually told me about that when those occurred.
Did you read, as one of the ODC exhibits, a brief that Mr. Criazzo submitted to the hearing committee titled "The Tale of the Promiscuous Prothonotary"?
Yes, I read that, in which he makes the allegation, but in the same document pretty much admits that it's based upon rumors he heard and conjecture.
Did you see where Mr. Criazzo accused you of filing a frivolous complaint?
He said that many times, but the board already found that it was valid, and the record speaks for itself.
Did you see, and do you recall reading an email that Mr. Criazzo sent to Chief Disciplinary Counsel in which he accused you of being, quote, dirty, unquote, and filing a complaint out of revenge?
Yes, I did see that.
Judge Beltrami, I would like you to go on in your own words then and tell this hearing committee how these false accusations have affected you both personally and professionally.
Well, anybody who knows me and knows Mr. Criazzo knows that this is absolutely ridiculous. But I have to say that my entire career as both a lawyer and a judge has been built on my reputation, and it's something that I value. I have 4 children, but I have 2 sons who are attorneys. One's a partner in a law firm in Allentown. The other's an associate in a firm in Allentown. And as I said, anybody who knows me knows that this is completely ridiculous. And anybody who knows Mr. Criazzo, his reputation over the last 35 years speaks for itself. He is been a thorn in the side of anyone who's had to deal with him over the last 35 years. So anybody who knows us both knows how ridiculous it is. But to have a lawyer put these things in writing, in pleadings, in emails, in filings, saying it in open court is really something that bothers me, not because of the fact that, of what he says. It's that people who don't know me or don't know him could still have this situation where they say to themselves, why is this allegation being made? And so for me, it's very, very unsettling because, as I said, when my kids were younger, we hung our keys on a plaque, and on that plaque was Proverbs. I have the plaque in my office here now, 22:1, and it says, "A good name is rather to be chosen than great riches." And that was something I pounded into the heads of my children. And I always said to them, it takes a lifetime to build a reputation, but it takes one mistake to ruin it. So be careful in everything you do because your name is everything. And again, as I said, I have 2 children who practice in the Lehigh Valley. I built up a reputation that I believe is unblemished in years as a lawyer, 15 years and 20 years as a judge. So even though, in my opinion, Mr. Criazzo has serious mental health issues, has serious delusional thinking, and if you read his documents, they speak for themselves. In one breath, he says this allegation. In another breath, he says it. And I was particularly going through the exhibits when I was preparing for this. And even if you look at ODC Exhibit 73, which is a transcript from a hearing, I don't remember. I think this might have been the disciplinary hearing. He says, right in this whole thing, now Beltrami does his thing, meaning I filed a complaint against him, and I will, let me just take my glasses off here, assert it was the Corey complaint was about the prothonotary, and I'll assert that Beltrami's complaint was about the prothonotary because he didn't like what I said to her back in August of 2022. And then he goes on to say, and there is no way that the two of them could have known that information without at least conversing about it. I'm not sure what he's talking about. But then he says, so while they may not have been in a sexual relationship, they were certainly in some kind of personal relationship. That's my position. That's my opinion. And then in his brief titled The Tale of the Promiscuous Prothonotary, he talks about this whole situation of how this delusion came about. And he says, now, the prothonotary's reputation is nothing new. I learned it from a colleague in 2015 who alleged to be a participant along with 4 or 5 other attorneys and 2 judges. So he's saying that he heard some person say this to him 10 years ago. And he says, why he burdened me with this story is beyond me. But what he described and what he implicated sounded plausible and credible to me. And this is on ODC 75, page 3. In any event, I did not suspect Judge Beltrami was a participant until after I presented the motion at issue here. And the motion he's referring to is the frivolous motion that he filed, which led to me filing a complaint for him filing that motion and then sending me a completely ex parte communication trying to influence my decision about the motion. But at the bottom of that page, he also says something about he believes that when he filed a lawsuit against 2 of the lawyers from the disciplinary board, and he alleges that when he filed it, the prothonotary called me. And even in there, you could just see how his delusional mind works. He said when he filed it, she ran back to her office and immediately phoned someone. Quote, my bet it was Judge Beltrami, end quote. And I've been dealing with Mr. Criazzo for 35 years, and when he gets a thought in his mind, it becomes fact. And if you look at all of the things he said and all of the things he's emailed and all of the things he has put in writing, you can see that delusional thought process just runs right through everything he does. And it's absolutely ridiculous on one hand, but on the other hand, it's serious. And it's why we have a rule that says you can't just make reckless statements about the integrity of a judge, because these are things he has said in open court and has filed, and I really, really take offense to them. It's not fair to my wife, it's not fair to my children, and it's not fair to anybody who has to see this or deal with it.
Thank you, Judge.
You're welcome.
I have no other questions for Judge Beltrami. Does any member of the hearing committee have any questions?
No, we have no questions. Although at this point, if Mr. Criazzo were present, I would offer him the opportunity to cross-examine. But since he has left this hearing, we take that as a waiver of an opportunity to cross-examine. So with that, Judge Beltrami, thank you very much. And I hate to say this to a judge, but you are excused.
All right. Thank you very much, and have a great day.
Thank you,
Thank you.
Judge.
Thank you, Judge.
You're welcome. Bye.
If he had any evidence for mitigating or aggravating factors on the penalty phase, but since he is not present, we will again take that as a waiver of his opportunity to present such evidence. Does ODC wish to make a closing argument or to reserve any comments for the briefing?
I asked of my counsel if she had a closing argument because she told me she had prepared an opening statement. I was not aware of that, and I didn't mean to deprive her of the opportunity to present her opening statement.
It appears to be, it's a pattern.
Yes, yes, I do apologize to everyone. No, ODC does not. I don't think a closing statement is necessary here. Mr. Creazzo is no longer present. He's voluntarily absented himself from these proceedings and no longer wishes to participate. We will submit our argument in a brief to the hearing committee.
Okay. Thank you very much. With nothing further, we can go off the live stream.
Okay.